Good evening, everybody, and welcome to Where There's a Will, There's a Way. My name is Jay Marsden. I will be your host this evening for a first of what we hope will be a series of conversations around some of the intricacies and some of the issues that come up around estate planning, many of which have been driven by some of our activity in the neighborhood as it relates to all this crazy pandemic stuff that's been going on. And as you can tell by this terrible haircut and this extended beard that I've been sporting since all this has started, we are still in the midst of the pandemic. And I actually bumped into some of the great folks at HCAT a little while ago, and they said to me, hey, is there a chance that you could come down to the studio and talk about some of the things that you've been talking about with folks so that we could actually put it out to the community at large and give everybody a chance to get some more information and get a chance to find out about some of the things that you've seen as an estate planning attorney and how you've handled some things with some clients. So as a result, we decided that we would put together this program. We hope you find it helpful, and if there's anything that we can help you out with, by all means, feel free to reach out to the station, and then they can let you know how to get in touch with anybody who can help you out with those issues. To start off the program, one of the things that I thought we would talk about as we sort of jump into this topic is what are some of the things that we have found have been on people's minds right now, given everything that's been going on. And as an estate planning attorney and as an elder law attorney, we have had a lot of contact for clients and a lot of contact for people who have reached out to the firm who have a lot of questions around things that they refer to or that we refer to as advanced directives. And when we talk about advanced directives and when we talk about planning with our clients, we talk about it in terms of three particular areas, or the way we refer to it as three legs of a stool. And the first area that we talk about the most with our clients, because we feel in many ways it's the most important thing that we talk about, is the idea or the concept of probate while you're alive. And the reason we talk about it as probate when you're alive is everybody knows, or everybody is familiar with to some extent, the idea of probate when you pass away, right? And that's if you have to use your will, and that's really the thing that people hear the most about, which is how do I get my stuff, if you will, from where it is right now to my loved ones and where I want it to go. But when we talk about probate while you're alive, we talk about the documents, things like these here that I'm holding in my hand, the documents that in many ways govern how decisions get made for you in the very unlikely event that something could happen to you. And the reason that we talk about them and the reason that we highlight why they're so important is because these documents come with some time sensitivity. So when we talk about probate while you're alive, the reason we mention the time sensitivity piece is that if you fail to do the planning around the probate while you're alive piece, what happens is you're caught in some sort of purgatory, if you will. You're caught in limbo from a planning perspective, because without having the appropriate documents, the appropriate advanced directives, decisions cannot be made for you if for some reason something should happen to you and you are unable to make those decisions. And the reason we talk about it as probate when you're alive is that probate court is where we go to solve these problems. So the problems aren't just probate when you pass away, when you think about distributing your assets to your heirs, but the probate while you're alive piece covers things like, do you have an appropriate or an updated current healthcare proxy? Do you have a current HIPAA authorization form? Do you have an advanced directive that would explain to somebody what your wishes are in the unlikely event that you might be incapacitated? And do you have the proper documentation to be able to name somebody who can make banking or financial decisions for you? Now, the reason it's so important to have these documents is that if you do not have these documents, probate court is where we go to solve these problems. And like any court system, it's a very public process. So for example, if somebody doesn't have a healthcare proxy or a power of attorney, to access your resources, to be able to take care of you, to be able to use your money to take care of you in the fashion that you may have hoped that you'd be taken care of, probate court is where we go to file paperwork, to file a guardianship petition, to file a conservatorship petition. And that starts a process that really takes on a life of its own. And at that point, you're in the system, if you will, and now you're marching to the probate court's drum. And sometimes when these things happen, you don't want to wait for things to unfold in the probate court. You don't have time for things to unfold in the probate court. Decisions need to be made quickly, whether it's accessing retirement accounts to help pay for your care, whether it's moving property around, whether it's moving you around, sometimes just getting you from the hospital to a rehab facility so that we can get you home. That needs certain people with certain authority need to green light that process. And if you don't have those people named, well, then it's going to drag this process out, and it's going to make it very unwieldy for your loved ones who are left behind to try to make those decisions. So when you go to probate court to address these issues, there's two things that you need to think about. Without a healthcare proxy, it's a guardianship process, all right? So you have to fill out documentation at the probate court. Somebody has to ask the probate court to be named the guardian, and that person would then have the ability to make decisions for you. Now, we joke with clients about this all the time. We try to make a little bit light of it if we can. We have a little bit of a black humor concept at the office. And what we worry about is if you don't name somebody, if you don't know who you want to have happen, you know, any crazy family dynamic that has ever existed in your life will rise to the top. So if you've got some dynamics between whether it's children, whether it's stepchildren, whether it's nieces, whether it's nephews, all of a sudden, for some reason that we've never been able to understand, people come out of the woodwork to decide that they want to be your guardian. And if you haven't made your wishes clear, you will be left in sort of the hands of this process at the probate court where they will decide, they will figure out who the best person to take care of you, who the best person to make decisions about you is going to be. That can lead to a lot of challenges internally in your family, and it can lead to a lot of challenges because in some cases, nobody might step up, and then you're really in a tough spot where everybody says, look, I don't want to take on that job, I don't want to take on that responsibility, and so we're not going to put ourselves in that position. So by having an advanced healthcare proxy that says, look, if I can't make a decision, this is who would make that decision, that's really, that's taking you out of the probate process and making it very clear what your wishes are. That's the path that we would prefer to go down. If you don't want to get on that path and you end up on this guardianship path, it's an expensive process. A lot of people are going to have to hire a lot of lawyers. We get involved in those situations all the time, and it's a challenge, and it's not the best way to use your resources. It's a public process. All these documents play out in the public sphere at the probate court. There are hearings. There's people that have to be notified. It sort of follows some of those Lifetime TV situations that you might have heard of. And it takes time. And sometimes time is not necessarily something that we have an abundance of, especially when it comes to taking care of you. So we try to avoid the guardianship process by making sure that we have that healthcare proxy in place and ideally a backup. Now, it may be time to revisit that. We hear this all the time from people. Somebody will say, Jay, don't worry about it. I have somebody named as my healthcare proxy. It's my sister, my big sister. She's 98. She's in a nursing home, and she's going to be able to make these decisions for me. That happens all the time. We name people in these documents at some point in our lives, and then time changes. Life happens. People that we name either become unable themselves to make these decisions, or we don't want them to make the decisions anymore. So you need to keep that in mind as you're thinking through some of these issues as to whether or not the people that you have are still the right people that you want to have, or should we be picking somebody else. Now, there's two other documents from a healthcare perspective that we try to make sure that clients have. One of them is a HIPAA authorization form. Now, what the HIPAA authorization form does is it gives somebody the authority to make decisions and inquire about your medical information, your protected medical information. Now, why is that important? Well, sometimes somebody might be able to make decisions about themselves, but remember, we live in a world where medically things get more and more convoluted as time goes by. And as we get older and as the technology changes, sometimes it's very, very challenging to translate the information that the doctor is giving you. Or when you're in the doctor's office, you're so completely overwhelmed by the information that's coming your way that you decide to say to yourself, you know what, I'm a little overwhelmed, I don't remember everything we talked about, and I wish I could give the authority to somebody to go ahead and gather that information to help me make an informed decision. Now, why do we do a HIPAA authorization form, or why do we recommend a HIPAA authorization form in addition to the healthcare proxy? Well, the thing that you need to keep in mind is your healthcare proxy does not kick in until something happens where you are no longer able to make decisions, okay? And the term that you hear a lot is, has your healthcare proxy been invoked? Has somebody said in a white coat or somebody in a clinical setting, for example, Jay does not have the ability to make decisions for himself anymore. We are invoking his healthcare proxy, and that means that I'm out of the decision-making loop, and the person who I've chosen to make that decision moves in. Now, I might not be incapacitated, but I just might need help gathering the information so that I can make an educated medical decision. And the HIPAA authorization form allows for that. It helps me, and it allows me to identify other people who can gather that information from the insurance company, from the doctor's office, from the pharmacy, and take that information and make that information helpful and make it clear and concise for me so that I can understand that and we can make that decision as a team. The other thing it does is it allows for, it makes it easier for me to give other people the ability to get information to help me out, and it avoids the situation where the insurance company or the doctor's office or the pharmacy is going to ask me to get on the phone and then answer that ridiculous list of questions. Who was my first girlfriend? What first street did I live on? What color car did I first drive? What was my dog's first name? You know, as we get older, especially if you're dealing with loved ones who have some cognitive issues, those things become harder and harder to figure out. And so the idea that we're working off of this, you know, my loved one is always able to hand me the phone and I can get that information, well, the time may come or the time may pass where that's no longer an option, or it's no longer an available or a workable solution. So we like to line that up ahead of time. And the third document from a medical perspective that we like to see our clients have is an advanced directive. We've received a lot of phone calls in the last 6 or 8 weeks around the idea of these advanced directives. And the advanced directive is designed to essentially let your healthcare proxy know, let the person who's going to make those decisions know, if I can't make this decision, what is the decision? And usually the advanced directive follows a blueprint around something like, if something were to happen to me, don't hook me up to every machine under the sun. Let's let care and comfort measure take over and kind of let me go gentle into that good night. Now remember, the reason that you write an advanced directive, or the reason that you have an advanced directive, is not for yourself. You know, I know, everybody knows what they want to have happen. These documents are for the people that are going to be making the decisions for you. And so by having that type of information available, by giving those instructions to your healthcare proxy, what you're doing is you're ensuring that your healthcare proxy does not spend the next 25, 30 years wondering and thinking to themselves, did I make the right decision? I was tasked with making a decision as my loved one's healthcare proxy, and then when the question came up as to what do, I didn't struggle with the decision. I didn't have no guidance. I had their guidance because they gave me the instructions. They told me what they would want to have happen in this situation, and it's peace of mind for the people that you're leaving behind. Now, we draft all these documents for our clients, and we try to make sure that our documents are with our clients, if you will, when they're going through some of these medical situations. And the reason that that's important is when somebody goes to a facility, when somebody goes to the hospital, when somebody goes to the doctors, the hospitals, those facilities, they want to make sure that those documents are in place for the same reason that we want to make sure that they're in place. If something were to happen and you were in a facility and there was no documentation as to who could make those decisions, those facilities know that the only path to clearing up that situation is a trip back to probate court to get a guardian appointed or to get a conservator appointed. And that can be a long and contentious situation, and the facility doesn't want to wait for that. If you're in a hospital room and you're taking up a hospital bed, the goal is to get you better and get you discharged. And if there's nobody around who can make those decisions to let you be discharged, to instruct the facility or instruct the hospital where you should be discharged to, you are going to be in this sort of care limbo until those people can get either appointed or nominated. And again, that can be a long process. It can be a contentious process. It's a public process. and it's expensive, and we'd rather have you spend your assets on yourself, taking care of yourself in the way that you want to be taken care of. So those three documents, your healthcare proxy, your HIPAA authorization form, and your living will or your advance directive, those we feel all work together on the healthcare side. If you have those documents in place, we feel like those documents are going to help you traverse any of those challenges that might come up on the healthcare side. And as we discuss this with our clients, we tell our clients, these documents that you have, the healthcare proxy, the power of attorneys, the advance directives, these are tools in a toolbox. And just like tools in any toolbox, we don't know how they're going to have to be used, but we know how they can be used. And in many cases, we draft them with a degree of flexibility so that they can apply to not every single situation, because we certainly cannot anticipate everything that might happen. You know, I had a conversation today with a client who wanted to add language around making sure that her doctors and her medical professionals could communicate through Skype and through Zoom and through some of these telecommunication systems that have been sort of driven to the forefront of care decisions because of the pandemic. So, you know, coronavirus has created these situations that 6 or 8 months ago, most people really could not necessarily envision that we'd be in this situation. So we draft our documents with a real degree of flexibility so that we feel like we can squeeze them into a lot of different situations so that we can make sure that we address them. And we have also been called on, while this situation has been unfolding, to help our clients use these documents and to help our clients understand what these documents are for and how they can be applied to many different situations. So one of the things that you want to think about is it's not just getting the document, it's also understanding how the documents work. And then it's also having the resources and the support system to be able to find out if these documents are being used, are they being used correctly, and are they being used to accomplish the exact objective based on what's going on at the time. So again, from a healthcare perspective, healthcare proxy, advance directive, living will, and your HIPAA authorization form, we feel like those have you covered. Again, probate while you're alive. This is not about something happening. This is making sure that your loved ones can take care of you from a medical perspective in case something should happen to you. Unlikely, but in case something should happen to you. Now, the other document that we talked about, or the other document that I mentioned, relates specifically to your power of attorney. Okay, that relates to your banking and your financial decisions. Now, some people will practice what we call Google law, and they go home and they look up powers of attorney online and they call us up and they say, Jay, I was told to make sure that I get a durable power of attorney. So what does that mean? Well, a durable power of attorney means it's a document that you sign, and when you sign it, it goes into effect. And if something were to happen to you, if you were to become incapacitated, the document stays in effect and it survives your incapacity. Now, that's the purpose of the document. The document is to give you, again, another tool as it relates to banking and financial decisions so that you can go ahead and have somebody make some decisions and take care of things and use some resources to paying for things while you are unable to make those decisions. Every once in a while, somebody will ask us for what we call a springing power of attorney. The springing power of attorney is the document that does not become effective until you have become incapacitated. Now, we tell everybody that the power of attorney document, it's the keys to the kingdom. When you give somebody a power of attorney document, you're giving them the ability to make all decisions as it relates to your cash, securities, money in the bank, real estate. I mean, you really are letting them take over and jump in the driver's seat. But the springing power of attorney, the definition for how we use it is, we tell people if you didn't have a person on this planet except your sketchy nephew or your sketchy niece or some sketchy friend or relative, that you were comfortable only being able to be in charge of your affairs if and when you were somehow to become incapacitated, but you don't want them in charge of things right away the minute you sign this thing, that's when your springing power of attorney would come into play. But for the most part, 9 times out of 10, the conversations that we have with clients are around a durable power of attorney. Now, the durable power of attorney that I'm holding up here as part of this package of documents, it runs about 13 pages. Now, we have been involved in situations, and clients will ask all the time, Jay, why can't I just sign a piece of paper that says, you can do everything I could do? Kind of like that song, right? You can do anything I can do, but better. So you can do anything that I could do. Well, the theory behind the way the power of attorney, the rules are written or the laws are written is, if the authority to do something is not in your power of attorney, then the authority to do that is not given to the person that you've named your power of attorney. So, for example, in many cases, clients will come to us and they'll say, Jay, I found an old life insurance policy and it has no beneficiary on it. Well, with the power of attorney, if it's written or drafted properly, we can use that power of attorney, we can use that authority in that power of attorney to add a beneficiary to that life insurance policy, so that if something happens to somebody, that life insurance policy would not have to go through their probate estate, which we'll talk about on a later show. But the idea is that we could name somebody on that life insurance policy who could then become the beneficiary. And we might look at some of the client's other documents to see what we think the client might want to have happen, and sort of take a sense of what's going on in the situation. And if push comes to shove, maybe we make the beneficiary of the policy a trust if one exists, but we would like to try to avoid something in terms of making sure these assets don't go to probate. So having that authority in the power of attorney would let us do that. If we don't have that authority in the power of attorney, then we're out of luck. Then we're forced to sit here and hold on to an asset that we know is going to have to go through probate, which we try to avoid for our clients because it's also a lengthy and it can be a time-consuming process. So the power of attorney document, equally as important. It takes you down a different path, but it really focuses on the ability to make banking or financial decisions. Now, in some cases, it sounds crazy. Everybody thinks of a banking or a financial decision as money, money, money. But now, because your home utilities, for example, have so much involved with your internet access, whether your heat, whether your air conditioning works, whether your lights come on, changing somebody's closing down, for example, somebody's policy at Verizon for cable TV or for their internet access. If somebody calls up, and I always feel like years ago you'd call, you'd switch over your services for some of these things, and it was easy to do. Well, now it's not easy to do. And if I wanted to call up and switch off or turn off a family member or my mother's cable TV or her internet access because she wasn't home anymore and she wasn't using it, they would require some authority for me to do it. They wouldn't just let me do it. So that's something that, it sounds like a little thing, but at $200 a month, when somebody goes into a facility or somebody's not home using these services, the ability to close down something like that, the ability to consolidate bank accounts, the ability to go into an account and use somebody's power of attorney to get money to pay for somebody's care starts to become a real challenge if the documentation doesn't give you the authority that you think it does. And again, if you don't have a properly drafted power of attorney, or you don't have a power of attorney, or the people who you named in your power of attorney document are no longer available, off to probate court you go, and now you're going to file to be named as a conservator. And it's a very similar process to a guardianship. A lot of people have to be given notice that you're doing it. Depending on the size of the estate that you're working with, somebody might actually have to file a bond with the probate court, which is essentially insurance that has to get paid year over year over year for as long as the guardianship, for as long as the conservatorship lasts. So again, you're incurring additional costs. You might have to incur additional legal fees, again, all of which can be avoided by just making sure that you have a properly drafted power of attorney to go hand in hand with those other documents that we mentioned earlier today. Now, the power of attorney document allows somebody to make decisions for you. But when something happens to somebody and they pass away, for example, the power of attorney is no longer effective. So a power of attorney is really only good for somebody's life. Now, why is that important? Well, we talk to clients all the time about making sure that if you're acting on somebody's behalf using a power of attorney, that you make sure that you understand that some of those assets that you might be working on and some of those assets you might be taking care of, those assets are going to be used only up until the life of that person. And then if something happens, then you have to take off your power of attorney hat, and then you have to put on your executor hat, and we start down a different path, and there's different rules to handle something like that. So the important thing to keep in mind is these documents, the power of attorney in particular, very, very important to allow somebody to make decisions for you and be able to manage your affairs, and in some case, get you eligible for things that allow you to continue your care and to kind of keep you moving along that care continuum. Without it, you could be in the same exact limbo. You can't access financial assets. You can't access your bank accounts. You can't access IRAs. You can't use those monies to take care of you. And again, the same issues that exist with the healthcare proxy exist around the power of attorney. Who is your current power of attorney? Is it somebody that's still in your life? Do you still want that person to be involved? Or do you need to upgrade that? Do you need to update these so that the person is either a closer person or it's children who have now become older and now can get involved in your affairs and start making decisions for you? And do you have to go through and make sure there's a backup so that if something happened to the person that was your primary agent, the backup agent could step in? So there's a lot of issues that we see around the healthcare proxy and your power of attorney. And again, it's really the case of making sure that they're updated and making sure that they cover your wishes and that the person that would be making the decisions is still the right person that you'd want to be able to go ahead and handle your affairs for you. These documents we feel are more critical than having a will and having a trust and having some of the other probate when you pass away documents. And the reason is because when these documents are needed, when we have to reach into the toolbox for these tools, time is usually of the essence. There's something going on that needs to be addressed right away. And those things, for any number of reasons, tend to not be able to be ignored, either because they involve somebody's care and they involve a response, or they involve a requirement that somebody be giving instructions to somebody about their care, or they involve resources, and they involve the access to resources, and they involve making sure that getting access to those resources can allow you to get the care that you want. So just to close out this portion of the show, we want you to make sure that your advance directives are available, that your advance directives are up to date, that the directives that you have in place represent your current wishes, the way you think about how you want your care to be handled. The idea of leaving these decisions to somebody else and saying they'll figure it out, in many cases they won't figure it out. And in many cases, the time that it takes to figure out the figuring it out, if that makes sense, is going to become problematic for you, and it's going to become problematic for them. We tell our clients all the time, proper estate planning is an absolute act of love for the folks in your life who would have to make these decisions for you. It's a difficult and challenging environment to have to step into somebody's shoes and to have to make those decisions. So everything that you can do to make things easier on them who have to make those decisions for you will be remembered for the rest of their lives. And we hear this from clients all the time. We had this done, and it made taking care of my parents or taking care of my loved one very, very easy, so that we could spend our time focusing on the time that means the most. And at the end of the day, that's really what having these things done and having them done the right way is really all about. Where would you rather spend your time? If something's happening to a loved one, if something happens to a family member and you have to make these decisions, do you want to spend your time sitting with them, holding their hand, doing the things that are important, doing the things that you're going to remember, doing the things that bring them comfort and joy? Or do you want to spend your time sitting in the lobby at the bank, fighting with the branch manager, fighting with the insurance people, fighting with the people at the pharmacy to try to get this information to help your loved one? So think about these things. Take time, think about them when you don't need them, and then make sure that when you do get around to it, make sure you talk to somebody about what the best way to handle your affairs is going forward, and figure out what the best way is for you and the best way for your loved ones, so that everybody can be part of this care plan together. Thank you very, very much, and look forward to seeing you next time.